Today's podcast is brought to you by Audible.com. Sign up for your free audiobook download and 30-day free trial at washingtech.com/book. Over 180,000 titles to choose from for your iPhone, Android, Kindle, or MP3 player.
Moving the needle. Welcome to the Washingtech Policy Podcast.
Curating communications, media, and tech policy news so you don't have to. News, interviews, everything you need without the axe to grind. It's the Washing Tech Policy Podcast with Joe Miller.
Apple defies the court order to unlock one of the San Bernardino shooter's iPhones. The U.S. admits to cyber strikes against ISIS, and Lita Rosario is my guest. With the ink barely dry on the court order for Apple to unlock the iPhone that belonged to one of the San Bernardino shooters, the FBI wants to unlock 12 more iPhones. According to Devlin Barrett over at the Wall Street Journal, the FBI has court orders in the works for these iPhones, and they're all in cases that are undisclosed. Meanwhile, Apple has been vigorously opposing the San Bernardino order by speaking out publicly. Apple CEO Tim Cook called it the technological equivalent of cancer, and on Thursday, the company filed a motion to vacate the order, stating that the order would give the FBI, quote, dangerous power. Apple's motion also states that the 1789 All Writs Act, which the FBI used to justify unlocking the phones, was never intended to, quote, conscript and commandeer the company, and that no law supports such unlimited and sweeping use of judicial process, end quote. Bill Gates came out in opposition to Apple, stating, quote, this is a specific case where the government is asking for access to information. They are not asking for some general thing. They are asking for a particular case, end quote. However, Gates made that statement prior to the revelation that the FBI is trying to unlock 12 more phones. Donald Trump has also backed the FBI, calling for an Apple boycott after Apple refused to comply with the order. Despite Gates' remarks, though, the company he founded, Microsoft, is coming out in support of Apple's position, as are Mark Zuckerberg and the Information Technology Industry Council, ITIC, whose members include Dell, Facebook, Google, HP, IBM, Microsoft, Nokia, and others. Ed Snowden has also been defending Apple on Twitter, saying it's the most important tech case in a decade. The carriers have been largely silent on the issue, though, with AT&T offering the most substance by saying Congress should decide how to balance public safety and privacy. John Ledger of T-Mobile empathized with Tim Cook, but only said the case is, quote, groundbreaking. A reporter who was working on the Apple FBI story on an American Airlines flight wrote for USA Today that he was actually hacked mid-flight while he was working on the story. Stephen Petro said a fellow passenger he'd never met approached him and said, "You're Stephen Petro, right?" and then proceeded to tell him he had hacked almost everyone's computer on the plane via the GoGo VPN, a public Wi-Fi service American Airlines partners with. The stranger said he had read everything Petro had sent and received. For the first time, the Pentagon has admitted it is carrying out actual cyber attacks against ISIS and the Islamic State. U.S. Defense Chief Ashton Carter made the announcement yesterday to reporters. This is the first time the Pentagon has expressed this openly. The President and First Lady have announced the creation of a new $250 million e-book initiative, which will offer award-winning titles to Title I military base and special education teachers, and by extension, students. It's called the Open eBooks, and it's available to any of the 66,000 Title I and 194 Department of Defense education activity schools in the U.S., as well as any special education teacher in any type of school. Thursday marked the one-year anniversary of the passage of the FCC's net neutrality rules, which the agency voted on 3-2 along party lines last year. But 4 Senate Republicans have introduced legislation to repeal it, including Mike Lee, who introduced the legislation, and Marco Rubio, Ted Cruz, and John Cornyn, who co-sponsored. The bill would invalidate the FCC's net neutrality rules and foreclose the possibility of the FCC ever adopting net neutrality rules again. Also last week, the House Commerce Committee compromised on a bipartisan bill to exempt small businesses defined as having fewer than 250,000 cable subscribers from the net neutrality provision requiring carriers to be transparent about their network management practices. President Obama has nominated Carla Hayden to serve as the new Librarian of Congress. Hayden would be the first woman and African American to serve in the role. It's been over 30 years since the last time a Librarian of Congress, James Billington, took the helm. Hayden currently serves as chief executive of the Enoch Pratt Free Library in Baltimore, where she kept the doors of the library open to the public during unrest following the death of Freddie Gray, who died in police custody after he was arrested for carrying what police alleged to be a switchblade. Hayden was also the president of the American Library Association. If confirmed by the Senate, Hayden would only be the 14th Librarian of Congress in American history. Hayden's primary challenge will be to modernize the 162 million volume library, making the collection more accessible to the public online. The New York Times reports that the Obama administration will soon release new rules permitting the National Security Agency, NSA, to share raw data of the email and phone call surveillance it collects with other agencies, such as the CIA and FBI, without first scrubbing the data of innocent Americans' information, a process known as minimization. The Times reports the effort to streamline the information sharing process between NSA and the other agencies has been going on since the Bush administration, following the September 11th attacks, when security agencies had to go through a whole bunch of red tape to obtain data from the NSA. Reporting on a conversation he had with Director of National Intelligence General Counsel Robert S. Litt, the Times' Charlie Savage indicated Intelligence Director James Clapper, Attorney General Loretta Lynch, and Defense Secretary Ashton Carter would have to sign off on the rules before they take effect, which would happen in a matter of months. Google Fiber is expanding. The company will now lease infrastructure from the city of Huntsville, Alabama, and has announced it will lease infrastructure in San Francisco as well, although the company has not announced who it will lease the infrastructure from in San Francisco. Google and Facebook are apparently interested in using the $250 million 4,000-mile direct cable link between Brazil and Europe, which Brazil is set to launch in 2017 in order to avoid U.S. spying. Brazil began installing the cable after Edward Snowden's revelations that the NSA was spying on Brazilian President Dilma Rousseff. So there's an open question as to whether Google and Facebook are seeking to use the cable to avoid U.S. spying as well. President Obama has signed the Judicial Redress Act. The act would allow some aggrieved European citizens to pursue civil remedies under the Privacy Act of 1974, provided that in return, the countries in which they reside share national security information with the United States. Last week, the Supreme Court heard oral arguments in 2 willful infringement or so-called patent troll cases. They were Halo Electronics and Stryker Corporation. Notably, Justice Stephen Breyer suggested that maybe Congress should develop intellectual property rules that apply specifically to software patents, as opposed to banging our heads against a wall about a statutory framework developed during the age of steam engines. Stay with us. Audible is offering a free audiobook with a 30-day free trial to give you the opportunity to check out their service. I love Audible. I listen to it whenever I'm in the car, which I'm often in here in D.C., and there's no better way to spend time trapped on the Beltway than to do something that's actually productive. And right now, I'm listening to Essentialism, The Disciplined Pursuit of Less by Greg McCune. It's about being more productive and achieving more meaning in our lives by actually doing less. Advice I desperately need as I continue to build this podcast and grow this business. In the book, McCune lays out a strategy for only focusing on the most essential activities to the exclusion of literally everything else. You can download Essentialism or another audiobook free by trying audible.com. Sign up for your free audiobook and 30-day trial today at washingtech.com/book. My guest today is Lita Rosario, one of America's foremost entertainment lawyers. Lita got her start in the entertainment business as a founder and the VP of Business and Legal Affairs for University Music, producers of multi-platinum recording artists Dru Hill, Sisqo and MYA. Lita has negotiated distribution and publishing agreements with all of the 4 major record distribution music publishing companies, including Warner Music Group, Sony RCA, Universal Music Group, EMI Capitol Records, as well as major television and cable companies, including Disney, UPN, TV One, BET, Viacom, MTV, Discovery Channel, E! Network, and Universal Pictures. Lita's client roster has included, among others, Grammy award-winning and platinum-selling artists George Clinton and the Estate of Garry Shider from Parliament Funkadelic, Missy Elliott, Tank, Sisqo, Dru Hill, Peaches and Herb, Crystal Waters, Afrika, Bambaataa, and Soul Sonic Force, Davy D, producer of Run DMC and Kurtis Blow, Ronald Peanut Frost, producer of Jill Scott, and Dave Evans, producer and music director for Keith Sweat. Lita's practice involves administration of copyrights, including negotiation of syndication rights, mechanical, synchronization, sample clearances, and performance licenses for music in major motion pictures as well, including Soul Food, Romeo Must Die, The Fast and Furious, Road Trip, My First Mister, Buying the Cow, and Brothers, as well as synchronization licenses for commercial ads. Lita is an adjunct professor at the University of the District of Columbia's Department of Mass Media, Visual and Performing Arts, teaching the business of music, a course focusing on legal, accounting, and other business aspects of music, TV, and film. Lita is a member of the District of Columbia, New York, and Massachusetts bars. Lita attended the Howard University School of Communications in D.C., where she graduated cum laude, and she also attended the Howard University School of Law, where she earned a J.D., graduating in the top 10% of her class. Lita Rosario. Today we're going to look at the changing face of music, both in the industry generally and particularly in the context of some of the policy and legal changes we've seen recently. Last month, the Recording Industry Association of America modernized its album certification methodology to include streaming to determine which albums have gone gold, platinum, and multi-platinum. In December, we saw the Copyright Royalty Board up the rate Pandora pays copyright holders from 14 cents to 17 cents per 100 streams. And the Department of Justice is currently reviewing the consent decrees entered into back in 1941 with ASCAP and BMI to prevent anti-competitive behavior because of new issues involving digital rights. We also see some new litigation in the world of hip-hop and some copyright issues that come into play there as well. So, Lita, thank you so much for joining me to help us understand these issues.
Happy to be here, Joe. So
let's start with the RIAA's recent changes to how it certifies albums. Can you give us some background there?
Sure. So in case your listeners don't know, the Recording Industry Association of America certifies sales of albums as gold, platinum, or multi-platinum to give attribution for significant thresholds or for sales. And what's been happening is that because album sales in general have been down significantly because of not only piracy and on-demand streaming and non-interactive streaming as well, people just are only buying singles now as opposed to albums. So many albums, in particular hip-hop albums, are not getting certified. So the RIAA they announced that they were going to change their certification requirements. And now on on-demand audio and video streams are being included for determining certification. So basically what they're doing is saying 1,500 on-demand song streams, including streams on Spotify, YouTube, Apple Music, Google Music, and others, are now going to hold the same value as the purchase of 10 singles or one full album. The result of this has been very significant. Just since the rule came out, they were able to go back and certify several albums like Wale's Ambition album, Future's DS2 album, Kid Ink's My Own Lane album, and J. Cole's 2 albums have been increased up to gold or platinum certifications where previously they weren't certified at all.
And what has been the music industry's response to this? And are artists comfortable with these changes? Do they go far enough?
Yeah, artists are very comfortable with the changes. I think we're all waiting to see if they really are a kind of real world reflection of the popularity of music. But it seems like a good start. I think artists and labels in general are happy that the RIAA decided to do this. And I think it's a good move for the industry overall. And in general, I think artists are pleased.
And there are a lot of changes in addition to the RIAA's recent changes that are happening in terms of how the industry is responding to streaming. The Copyright Royalty Board raised the royalty rates artists would receive from streaming platforms from 14 to 17 cents per 100 streams. Is that right?
Yes, that is right. And that's a pretty significant ruling. And once again, it's important to distinguish between on-demand and non-interactive streaming. In the first instance, when we were talking about the RIAA Gold certifications, that is for what we call on-demand streams. So that's when the consumer actually makes their own determination that they want to hear a particular song and they stream it themselves. In this case, with the CRB ruling, this is regarding non-interactive streaming. So this goes to Pandora, iHeartRadio, and a bunch of small commercial webcasters and other, major radio conglomerates that have developed, their internet sites for their radio stations. So this is significant because just as in terms of annual revenue, there's an entity called Sound Exchange that collects this money. We call this money performance income on behalf of artists and labels. And the money is basically divvied up. 50% of it goes to the labels or to the copyright owner, the entity that owns the actual recordings. And the other 50% is given to the featured performers and the side artists and the background singers and musicians who are featured on the records. So this is a pretty significant ruling. Pandora, who pays the majority of the royalties that go into Sound Exchange, they're probably the biggest non-interactive digital music provider. They were actually trying to get the rates lowered to 11 cents, and the labels were trying to get the rates increased to 24 cents. So the 17 cents is kind of an in-between amount that the CRB went with. Pandora has stated publicly that they can work with that, but a lot of smaller webcasters are very concerned because they think it's going to put them out of business.
And tell us about what's happening in the DOJ's review of the consent decree it entered into with ASCAP and BMI back in 1941. Can you tell us a little bit about what ASCAP and BMI are, the nature of that consent decree, what the DOJ is revisiting, and how the public has been responding?
Sure. So ASCAP and BMI are what we call performing rights societies, and they collect royalties for the public performance of music on behalf of songwriters and music publishers. So previously in the two instances, we were talking about changes that affect recording artists and record companies. Now these new changes that are being proposed in terms of ASCAP and BMI are going to affect songwriters and music publishers. And ASCAP and BMI collect royalties, approximately 6% of music-related income from broadcasters, radio stations, and TV and cable stations, concert halls, and others, and they pay out royalties to songwriters and music publishers. ASCAP has been in existence since 1914. BMI came along sometime later. It was a response kind of by the broadcasters to having an alternative. But there were many concerns back in the 1940s that ASCAP and BMI were acting in an anti-competitive manner. And so under the Sherman Act, the DOJ came in and issued consent decrees that are being monitored by the courts. The Southern District of New York is the court that monitors these consent decrees. These issues have now come up because it's really been since 1941 that there's been a major review of these consent decrees. There have been a few others along the way, including as recent as 2001 for ASCAP, but nothing that's really dealt with digital rights. So this new review really has a lot to do with the digital rights, and it's in response to concerns by many of the major music publishers. They're threatening to take their catalogs away from ASCAP and BMI because they want to take just the digital rights and do arm's length negotiation deals with third parties to collect performance royalties without going through ASCAP and BMI. And this has caused some concern for ASCAP and BMI. And frankly, it has some concern for attorneys like me who consider themselves to be the advocates for artists and songwriters, because if major labels are allowed to take their catalogs out of ASCAP and BMI, songwriters won't be able to collect their royalties directly anymore. So as I just mentioned with Sound Exchange on the recorded music side with artists get paid directly. Half of the money comes to the artists. The other half goes to the record companies. Well, ASCAP and BMI have similar systems in place. In fact, theirs predate Sound Exchange systems where they pay 50% of the money that they collect directly to songwriters so that that money doesn't get caught up in the deals that songwriters may have with music publishers, and they take advance monies and they're unable to collect their royalties. So this system of having, this dual payment where the actual creators get money directly is something that is really important because many creators use that money. It ends up being their retirement. It ends up being the money that they're able to live off of as they grow old and money that they're able to pass on to their heirs. So for those of us who are on the artist rights and songwriter rights advocacy side, we're a little concerned if major music publishers would be able to take their catalogs out of ASCAP and BMI and license digital rights directly. So that's what's going on. We don't have any decision from the DOJ yet. They did take comments from the industry, directly from songwriters, major music publishers, and independent publishers, and other advocacy groups. So we're still waiting to hear what the outcome is, but we're all kind of anticipating what may happen. And hopefully, whatever happens, it will preserve this payment system where songwriters are able to collect their money directly.
And I want to get into an issue that's just fascinating to me personally and professionally, because I was growing up in New York, when people had the Latigua shirts with the collars popped up and the name tags and the nameplate belts and all of that. And I actually used to work. My first job in radio in the early years was at Hot 97, but they were playing dance at the time.
Wow.
So this runs deep for me. But I want to find out a little bit more about this complaint you filed in the Southern District of New York on behalf of Soul Sonic Force not too long ago for some music they made with Afrika Bambaataa back in the 70s. Can you tell us the facts of that case and what the basis for that complaint is?
Sure. So the Copyright Act has a provision in it that will allow artists and songwriters and other authors to reclaim ownership of their copyrights after 35 years from the date that they made a transfer of those rights to a record label or a music publishing company or to anybody else for that matter. And so I have filed a complaint in the Southern District of New York to get a declaratory judgment that a notice of termination that I sent to Rhino Records and Tommy Boy Records on behalf of Afrika, Bambaataa, and Soul Sonic Force is effective in that they will get the reversion of the rights in their master recordings. Many of your listeners may be familiar with their iconic hits, including the song Planet Rock, which sampled a song called Trans Europe Express by a group called Kraftwerk.
Let me play a clip of that right now. So now that's what your complaint. That's what the complaint was based on.
Yeah, that's the essence of the complaint. There's some underlying breach of contract issues, but what we're asking the court to do is to review the notice of termination and the recording contract and make a determination that Afrika, Bambaataa, and Soul Sonic Force do in fact own the copyrights effective as of the date in their termination notice. So this is a very important issue for the music industry because most recording contracts have provisions in them that say that master recordings are created as works made for hire. And that's the one exception to being able to secure your reversion of your rights under Section 203 of the Copyright Act as if they were, in fact, works made for hire. So what we're going to be asking the court to do is to review the facts and circumstances of this particular case and make a determination that those master recordings for Planet Rock and their other two iconic hits, Looking for the Perfect Beat and Renegades of Funk, are not works made for hire and that they are referring to Afrika, Bambaataa, and Soul Sonic Force.
Gotcha. So, Lita, thank you so much for joining me. It's been a privilege having you on the show. And I just want to ask you a few more questions, and then we'll close.
Sure.
All right. So on this podcast, we like to talk about policy, but also the people behind the policies and what makes them successful. So tell us, Lita, what are some habits, tactics, and apps that you use to stay on top of your game?
Well, I subscribe to IP Law 360, and so I keep up with policy and legal issues that come out there. I'm also on a couple of LinkedIn groups, including the Media and Entertainment group, the one that deals with music royalties. And I also do the Media and Entertainment Law 360. So that's pretty much how I keep track of things that are going on in the industry. And then, of course, your blog, Joe, which is very important. So that's pretty much what I do.
So tell us the name of a book that you read recently that you're recommending to basically everyone you meet.
Sure. So for those people in the music business on the policy side, I think a great book is a book that the American Bar Association publishing arm put out called Music and Copyright by Kevin Parks. It's an excellent historical account of the music business and will help put into context much of the stuff that we talked about today on your program. It's a great read if you want more information about what we've been discussing. And Kevin Parks has done a great job, a historical job, and brought us all up to date on the issues regarding music and copyright.
All right. Thanks again, Lita, for joining me. Do you have any final ideas you'd like to leave with the audience before we close? And where can folks find you online?
Oh, sure. Folks can find me online at my website, which is wisegirl.com, and that's WYZGIRL.com. That's pretty much the best place to find me. You can go to the contact link and contact me. And I think in general, people should just stay abreast of what's happening in the news, pay attention to what's going on, because artists and other creators, this is a time of change, and we want to make sure that they get adequately compensated for their creative work.
And you've been listening to Lita Rosario, lawyer to the stars and principal of Wise Girl Entertainment Consulting here in Washington. Recently, Lita filed a complaint in the Southern District of New York to secure master rights for hip-hop icons Afrika, Bambaataa, and Soul Sonic Force. So, Lita, it's been wonderful having you on the show.
Great. Thank you, Joe.
That concludes episode 28 of the podcast. Thanks so much to all of you for listening. I cannot do any of this without you, so thank you. Before I let you go, I want to give you a heads up about our weekly Data Points newsletter. If you're interested in tech policy, you're going to want to stay on top of the research behind it. And that includes government and scholarly reports on things like broadband adoption, how consumers use social media, education trends, and more. Every Thursday, I send out a summary of all the tech policy-related research and data that came out the week before for you to use to populate populate your own information products, such as white papers, blog posts, and infographics. You can find the sign up for that at washingtech.com, and you should see a box at the top of the page that lets you sign up. Thanks so much to all of you for listening, and I will see you back here next week. Take care.
Thanks for listening to the Washing Tech Policy Podcast. You've been briefed.